The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Thank you for coming to today's webinar. GDPR is here. How to make sure your software providers are compliant. And we have with us today our own Director of Risk and Compliance, our own in-house GDPR expert, Amanda Finch. And she's going to be talking to you about how you can ensure that your software vendors, whether it's Time and Expense or any other software vendors that you use that may be handling personal information, how you can ensure that they're compliant with GDPR, which the deadline for that was on May 25th. And so hopefully some of you are, if you were planning on becoming compliant, then you were able to get through all of the requirements for that. But this is obviously something that's ongoing. So we want to make sure that you are prepared for that. And I'll just give you a few little housekeeping items before I hand it over to Amanda. First of all, we are recording this, and so we will make this available to everyone. We'll be sending it out via email. We'll also be putting it on our website. And we will also be having a Q&A at the end of the webinar. So if you have any questions at all, feel free to pop those into the questions panel in your GoToWebinar panel. And so, without any further ado, Amanda, I will let you take it away from here.
Thanks very much, Carrie. And thank you, everyone, for attending today. GDPR is certainly a very broad topic and a very timely one. We are taking this very narrow slice of that topic today, which is making sure your software providers comply with the GDPR. Obviously, it makes sense to make sure that we're all on the same page about what GDPR means, because after all, there has been a lot of information, misinformation, humor, and otherwise bandied about on the internet regarding GDPR. So GDPR is the General Data Protection Regulation. It is the European Union's privacy regulation. Now, it replaces an old European Union regulation, which was actually in the form of a directive that was promulgated in the mid-90s. And that created a patchwork quilt of privacy regulations for each of the individual EU member state countries, which was certainly confusing, to say the least. And this replaces that with one regulation. Now, it's important to understand that GDPR gives vastly increased rights to individuals. These vastly increased rights create increased obligations for organizations that in any way handle the personal information of individuals located in the European Union. As Carrie mentioned, the deadline to comply has come and gone. It was on May 25th. However, many organizations, even if they've achieved a state of compliance today, are still setting in place processes to ensure that their supply chain is compliant where that's applicable. Often that is software vendors in the supply chain. And certainly many organizations are struggling to clean up those last loose ends to get into compliance. It's a very, very large effort to achieve compliance. So the deadline struck fear into the hearts of many. It is important for us to briefly touch on how GDPR does apply to you to understand your obligation when selecting a software vendor that's compliant. So one point of confusion is to understand how it applies to both European Union and non-European Union companies. And it does apply to companies that are not in the EU, which sounds very strange. We're certainly not accustomed, at least in America, to having the laws of other countries apply. And yet GDPR, if your organization processes or collects or otherwise handles this personal information of EU individuals, it will apply to you. Now, it'll apply to you and your vendors in a couple of different ways. GDPR considers an organization that obtains the services of a software vendor to be the data controller. So GDPR talks about two roles, a data controller and a data processor. And if you hire the services of a software vendor, you're in the role of a data controller. What does that mean? A data controller under GDPR determines, either alone or jointly with others, but your organization decides to get this personal information for some purpose. You know what that purpose is, and you decide what you're going to do with that information to achieve your business outcomes or to set up a business process. And from time to time, you may decide that you need some software to help you achieve those outcomes, and personal information will be among the data entered into that software system. So GDPR calls you, your organization, a data controller. The software vendor that you might engage with under GDPR is referred to as a data processor. And a processor takes the information and does something with it, executes some sort of processing, and this is on your behalf and at your express instruction as the controller. After all, if you selected the vendor's software, you did so knowing what the software does, and in other words, the vendor is processing the data at your request. GDPR refers to controllers and processors very often, so it's kind of important to set out at the beginning that the organization obtaining the software service is the controller and the software provider is the processor. But I do want to briefly mention that GDPR thinks of and regulates personal information differently than the United States, for example, companies are accustomed to, and probably organizations in other countries are accustomed to. Certainly, here in the US at least, we think of personal data that are regulated to be things like name, social security number, information that could identify a particular individual. Not so with GDPR. GDPR will regulate the information if it can be used to individualize a natural person, separate them from other individuals, even if you can't identify the person. And that's a little hard to understand. Let me give you a specific example. IP address. If your organization, for example, collects the IP addresses of visitors to your website, let's say, and over time you notice that the visitor associated with that IP address takes certain actions on your website and you record that, or you notice other things about that particular visitor at that IP address, and you begin to gather information and look at information associated with that individual. You don't know the identity of that individual, but you have individualized them. You know it is a person, or you can reasonably suspect it's a person and not, let's say, an AI robot, and you can separate that person from other people. You have individualized that website visitor. Under GDPR, the IP address and all of the other information you've associated with that visitor become personal data regulated by GDPR. So that is definitely a little different, and I thought it important to make that distinction for you today. Let's briefly touch on the key elements of GDPR that come into play if your organization is going to seek the services of a software vendor that must also comply. As we mentioned, the data protection law applies outside the European Union. So obviously, if you were to select a non-EU software vendor, you need to understand if EU data will be entered into the system because it will cause GDPR to comply. Please know that there are tough sanctions for non-compliance, up to 4% of global revenue, and that's for everybody in the chain. So GDPR is very far-reaching and has real teeth. Among those teeth are a very strict data breach notification obligation. As the data controller, if the software vendor you choose suffers a breach and that causes personal information to be stolen or accessed by unauthorized parties, you have a 72-hour window in which to notify the relevant authorities. So you have to make sure the software vendor works with you to help you meet that obligation. Avoiding data breach is just one part of a strict data privacy governance stance that is taken under GDPR. For many organizations that aren't among the large enterprises of the world, this will introduce many new and potentially onerous requirements, such as complete data mapping to discover all personal information that resides everywhere within your company and in what systems, what have you. Privacy impact assessments have to be performed. In your case, if you seek to engage the services of a software vendor, you, under GDPR, would need to assess the data privacy impact to your organization or other individuals involved when you choose and use that software. And these same requirements must also be met by the software vendor that you choose. All of this is part of GDPR's philosophy of privacy by design. GDPR requires that organizations no longer think of privacy as an afterthought. Privacy must be designed into products, services, and business processes from the beginning rather than afterwards as a tack-on. All of this is necessary because of the fact that GDPR has so strengthened the rights of individuals with regard to their personal data. Individuals now have the right to approach organizations to ask what data they may possess about the individual. And in many cases, those rights can include things like the right to ask for corrections, the right to understand if you're automating any decision-making with that data, the right to be forgotten, the right to ask that information be deleted. Now, these rights aren't absolute. There are certainly some legal boundaries to an individual's rights, but by and large, it is a tremendous broadening of power any individual has with regard to data a company would hold about that individual. These many enhanced requirements impact the supply chain management activities you undertake. Obviously, today, we're talking specifically about software vendors in your supply chain. And GDPR, if it applies to you and must also apply to your software vendor, is going to cause you to have some, shall we say, enhanced requirements with regard to supply chain management. So with that in mind, let's talk about how you might approach the question of whether your software vendors, current vendors or ones that you seek to hire in the future, are compliant with GDPR. The first thing to ask, and the most important, is, are the necessary terms and conditions for GDPR compliance in the vendor's contract? GDPR mandates that the contract between the parties contain many terms and conditions set out in the regulation that constitute compliance with GDPR. But at the highest level, if it ain't in the contract, it isn't compliant. So you'll need to verify if the software in question will contain the personal information of any individuals located in the EU. If the answer is yes, then GDPR compliance must be a contractual requirement that's met in the contract between the parties. Data privacy, which is what GDPR is all about, obviously requires that you and the software vendor restrict access to personal information. So definitely ask a software vendor if their system can restrict data access and do so in the appropriate ways. Most often that's according to a user's role in the system, and generally speaking that might correspond with a job role, for example. And the reason for this is that you have to be assured that personal information of the users of the system can only be seen by the user. And then, because software, after all, has to be used to do something, the others who can see that personal information must have a legitimate need to know. Examples include user supervisors or managers, of course. But generally speaking, if anyone who uses the software can see everyone else's personal information, that probably doesn't fit the description of appropriate restriction under GDPR. You'll want to ask if the vendor can evidence the technical and organizational measures that are necessary to comply. Now, the technical and organizational measures are around data security. Obviously, these can be highly technical measures. And then organizational processes that ensure confidentiality and bind the software vendor's employees to certain activities and avoidance of others. You, as the data controller, are required to perform due diligence to verify that your vendors don't just say they comply. You're required to verify that they actually do comply. Because if they do not actually comply, then neither do you when you're using their software. You will need to ask a software vendor about the cross-border mechanism they are using for the legal transfer of personal information from the EU. Now this particular point is a little confusing. I want to spend just a minute or two on this one. Some years ago, the European Union looked out at other countries in the world and determined, do these countries do an adequate job of protecting the privacy of individuals? If we deem that they are inadequate at protecting privacy, then it is illegal for European Union countries, companies and individuals to transfer personal information to that inadequate country. And guess what? The United States was deemed inadequate. So I'm talking to you about software vendors in the United States. This might also apply to other countries that were deemed inadequate, but 90% of the time, this is a question you would be dealing with if you're dealing with a U.S. software vendor. So the EU declared the U.S. privacy inadequate. It becomes illegal to transfer data to a software vendor located in the U.S. Well, you might notice that software vendors in the U.S. have been doing business in Europe despite that fact for a long time. How is that possible? It was made possible by an agreement between the government of the U.S. and the government of the EU. And they put their heads together and said, look, we've got to have a way to make it legal. Their answer was a framework. Some years ago, that framework was called Safe Harbor. You may have heard of that. Today, that framework has been updated and is now called Privacy Shield. So this framework is essentially an agreement between the respective governments, which says if a company in the United States, a country we deem privacy inadequate, if that company agrees to certify to and abide by this framework that we deem adequate, then it is okay and legal to transfer data to that company. So this framework, this agreement between the governments, makes it legal to do business with that U.S. company. And the Privacy Shield framework is the most common one that is used, and that's for a couple of reasons. So the United States software vendor can certify to Privacy Shield with the United States government. It's very easy to verify their participation in Privacy Shield because you can check the U.S. Department of Commerce website where they have a list of Privacy Shield vendors. I think a simple U.S. Department of Commerce Privacy Shield company list search in Google would take you right there. So it's very easy to verify that any U.S. software vendor has this framework in place to make it legal for the data transfer to happen from individuals in the EU. Now, another thing to note is that the Privacy Shield framework allows the FTC to enforce the tenets of the framework against U.S. companies that violate them. And without this enforcement mechanism, the EU would never have agreed to it, never have agreed to make this a mechanism for making the cross-border transfer legal. Now, Privacy Shield is easy to verify if your software vendor is listed on the list. There are other cross-border mechanisms that can be brought to bear. They are usually contractual language, and these other mechanisms are usually done on a lawyer-to-lawyer basis between the respective companies. But Privacy Shield, again, because it's so easy to check with the US government to verify what you're hearing from the vendor, it's the one you see used most often. You'll want to ask yourself when you engage with software vendors whether you are clearly obliging the vendor to do nothing more with the data you load into that system than what is strictly necessary to provide that software service, that functionality to you. So you must also then clearly understand the types of data you will enter into the software system and what you expect the system to do with it. You've got to make sure that you and the software vendor are clear about what the software does and, most importantly, doesn't do. Because under GDPR, it is not permissible for a software company to do something entirely unrelated with that data, such as, for example, selling the data to third parties to create another revenue stream. And that is certainly not unheard of in today's world. GDPR expressly prohibits that sort of thing. So that's another thing you need to check the contract. Make sure that the contract doesn't have some kind of weaselly language that lets the software vendor take the data and sell it off elsewhere. Even if they say, well, we're going to pseudonymize the data and sell it, GDPR still doesn't permit that. You'll also want to ask the vendor if they use any third parties to provide any part of the software service to you. Now, as you remember, GDPR likes to call you, the controller, and that software vendor your processor. Well, if they use third parties to provide the service to you, those third parties are called sub-processors under GDPR. So you need to know if they're using sub-processors because those sub-processors must also comply with GDPR. The regulation is very clear on that. So you can not only verify your vendor's compliance, but you must also validate that the sub-processor complies. Now, that's great, but there's another question to ask, and certainly you want to look in the contract for this. If the vendor decided to switch sub-processors in midstream, midterm in the contract, and you didn't know about it, and the sub-processor didn't comply, well, then you would be out of compliance as well. So it's very important that you have advance notice if the software vendor intends to change sub-processors in sufficient time to allow you to object if you deem the sub-processor non-compliant. So that is an important question, an important thing to check when you're contracting with software vendors. So we'd like to take these broader software vendor issues and maybe shed a little more light on them by talking about how Journyx, as a particular software company, complies with each of these. I happen to know how Journyx complies very well, so I can speak to this with some degree of confidence. And maybe the specific examples will just help to make this a little clearer. From time to time, your organization, or any organization I should say, will find their legal counsel advising, hey, for this particular piece of software, given all of the compliance requirements, we'd like to put some kind of notice to the software users, some kind of additional information, just notifying the users of the system why we're collecting this data and what we're going to do with it. That's not always required. It would be depending on what type of software it is, what you're doing with the data, but from time to time your general counsel might advise it. So if they do, you would want to just make sure that the software permits you to provide that information from within the software. And this is just an example of how the Journyx system in particular does it. We can display notifications at the login screen, which is at the point the user might enter data into the system. Again, not always required, but if your corporate counsel advises it, it's just a question to ask, hey, can I do this? And could I do it at the login screen or somewhere early on? To the question of keeping out unauthorized parties, ensuring that they can't freely access all the personal information that might be in the system. Here is a specific example of how we choose to do that at Journyx. We implement technical measures in the software that create a very fine grain. I mean, you can see all the detail on that screen that show the extreme granularity that you can go to in restricting access to data by user role. Now, we also offer our software as cloud service. And for that cloud service, we implement many technical measures for data security and privacy. And so that combination of overall defensive measures for data security and privacy, and then having that granular way to restrict and control data access from within the software is very powerful to ensuring that only the people who should see the personal information that happens to be in the system will see it. And then where the technical and organizational measures required by GDPR are concerned, obviously we choose Privacy Shield. We talked about how that's easy for companies to validate. We're on the Department of Commerce website. We reveal who our sub-processors are. In our particular case, it's Amazon Web Services. So all of these things, both technical and organizational, that Journyx does, we choose to set that out very clearly in a data processing addendum for GDPR compliance. It's an addendum to our master agreement for our software use. This is not at all uncommon, and if you are working with a software vendor where GDPR applies, I would suggest asking for that vendor's data processing addendum. It's how a lot of companies are handling that. And then it's not enough, obviously, for a software vendor to simply say they have all of these technical things in place and all of this confidentiality process in place. That vendor has to prove it to the organization hiring the vendor. And here's how we choose to do it. This too is not at all uncommon for software vendors, but we choose to undergo external assessments annually. And this is by an accredited audit firm. So it's not our own assessment, it's an audit firm that's been accredited and certified by PCA. And we have that external audit done annually. The auditor looks at specifically our data security controls and our privacy controls and issues a report on that. So we can provide that to companies so that they can show, hey, we have verified, this external party has verified. They don't just say they have these measures in place, they're actually in place and someone has audited them. As I mentioned, we certify under Privacy Shield, we use Amazon. Now, that is spelled out in our data processing addendum. So all of these things, what's the legal basis, what's the framework, who are your sub-processors, all of that we locate in the data processing addendum, and you'll have to find that somewhere in the vendor's contract. And then just to wrap up at a very high level, you'll want to consider how any vendor just generally approaches protecting the personal information they'll process on your behalf. And in our particular case, we differ from some cloud software companies in some key ways. Obviously, we never share your timesheet data with anyone. We do not have a sideline business selling off the data or even statistics about the data to create another revenue stream. We don't share it, period. And we take it a step further. We don't even administer our customers' timesheet systems. From our perspective, that creates an additional layer of data privacy and security. We can't see the data you're entering into the system. We don't even know what it is. Obviously, from time to time, a customer might ask for our help, and request that we work with them with their data. But even then, we'd only do it at the customer's request. And when the work is done, we then work with the customer to lock ourselves back out of the system, destroy the data, and once again, we're back to situation normal. We don't look at we don't even know what's in it. So it's very hard, obviously, to even inadvertently disclose information you aren't looking at and can't see. So those high-level privacy protection stances and philosophies are things that you may want to ensure are in place with the software vendors that you're engaging with. We wanted to have a very brief webinar, and we have had a very brief webinar about a very broad topic, I know. So we did want to not only thank you for attending today and wrapping your head around something as vast as GDPR, but also open it up to any questions you might have at this time.
Yes, thank you, Amanda. Thank you for unpacking this somewhat complex and even still ambiguous topic for us. Even if it is just this small slice of it, it's still very helpful if you are shopping for, if you're evaluating any new software vendors, and certainly if your company is using, and certainly what company is not using some sort of software, whether it be for marketing or for finance or for support and customer service. There's so many different ways in which personal data can be touched and be stored. So this is extremely important, and I thank you for shedding a little bit of light on this for us, Amanda. So if you do have any questions, like I mentioned at the beginning of the webinar, go ahead and put those into the questions box, which is in your GoToWebinar panel. And we will take a little bit of time to answer those. And I do have, Amanda, a couple of questions for you. The first one is, in general, what kinds or what types of documents do I need to properly evaluate vendors?
Certainly the ones we've mentioned in this webinar. Look first at the vendor's contract. Now, I mentioned data processing addendum is the name of an addendum that we use. But some other ways to identify the applicable contract, the terms and conditions between your company and the vendor, would be to look at the terms of use. Some vendors will present these online. If their public website is also a gateway into their cloud software, you may find it on the vendor's website. You may need to ask the vendor for the contract, and it might be provided to you separately by email. You would want to look at the vendor's privacy policy as it applies to the software. And to that particular document, I will just say, be careful. If the vendor points you to their website, there may be two different privacy policies in play. One might apply to just the public website, and another privacy policy might apply to the software. So you want to make sure that the vendor is pointing you to the privacy terms that apply to the software service. And then the other documents, obviously those verify the contractual requirements are in place that GDPR requires. But remember that you also have to verify that the proper technical and organizational measures are in place at the vendor's company. And so again, sometimes a vendor will provide documentation about their security controls on their website. So that's certainly a good place to start looking to verify their technical and organizational measures. But again, if they have a nice description about how good they are, that's not sufficient. You need a way to verify that they've got adequate data security in their company, that they've got confidentiality, and asking for an audit report is a very good way to go. There are different kinds of assessments and standards that you could use. There is not yet a specific GDPR certification. So most companies are looking to things such as the vendor's SOC 1 and 2 audit reports. If you've ever asked for an SSAE 18 audit report, that would be one of the SOC reports that you could ask for. Some organizations choose to ask for an external audit of an organization's ISO 27000 to the ISO 27000 standard. So honestly, companies are struggling with this, but I would just say make sure the contract is correct, make sure they deeply describe their security protocols and systems, and then pray that there's some kind of audit document that will let you be able to convince a regulator or your own auditors that you've reasonably assured yourself that the vendor actually has those security controls in place. Carrie, did you have any other questions?
I apologize. I was on mute. So there, you mentioned several ways to obtain documents, some of which involve directly engaging with the vendor in some way, whether that be through sales or some other way. But what is there a way, and you may have answered this already as you were explaining your answer to the previous question, is there a way to tell if a vendor is compliant before you engage with them? You mentioned the website. Is there maybe another way?
For full compliance across all of the requirements for GDPR, no, it would be difficult. You wouldn't have to hire the vendor to determine compliance, but you probably would have to talk to them to figure it out. Now, if you wanted to narrow a list of vendors to those who are most likely to be compliant, I certainly would look at the vendors' websites to see if they talk about GDPR compliance, because if they don't mention it at all, well, doesn't mean they don't comply, but it probably implies that they might not. Obviously, while this is not the entirety of GDPR, you can certainly check to see if a vendor is listed on the Department of Commerce website's list of Privacy Shield certified vendors. It's very easy to check. And if they certified a Privacy Shield, while that won't get the vendor all the way to GDPR compliance, it's a really important first step. So that's another thing you might do. But again, because there are other ways than Privacy Shield compliance, for example, the lawyers of both parties can get together and add more stuff to the contract. You know, it's not necessary, but it sure is an easy way to get started to narrow down the list.
All right. Well, thank you very much, Amanda. We do not have any other questions, but I do want to mention that if you look in your handouts section of your GoToWebinar panel, you can find a PDF that answers some of the questions about Journyx that Amanda answered today, so you have that in a document form. And as I mentioned at the beginning of the webinar, the recording for this will be sent out tomorrow, should be sent out tomorrow, and it'll be emailed out and put on our website. So I appreciate Amanda, thank you so much for your time today. I appreciate everyone for attending, and have a great rest of your day.
Thank you.